The Court of Appeal will today determine an election petition filed by Embu Governor Martin Wambora. In February, the High Court in Embu nullified Wambora's victory and ordered a fresh election. Delivering the ruling, Justice William Musyoka ruled that the petitioner, former Embu Senator Lenny Kivuti, had provided sufficient evidence to prove cases of massive irregularities. The judge cited cases where Wambora got more votes in certain polling stations, surpassing the number of registered voters. He further ordered that Wambora pay Kivuti 2 million shillings in costs. The governor says that the judge erred in misconstruing, misrepresenting and misapplying Regulation 81 of the election in the context of the scrutiny and recount of votes.
And the earlier decisions cited above, that is of Peter Gishuki Kingara and Zakaria Okoth Obando. First, in Moses Masika Wetangula, the court was dealing with a situation of an illegality as opposed to an irregularity. It was a case where election offences of treating of voters and bribery, contrary to Section 62 and 64, respectively, of the Elections Act had been alleged. The Election Court, by the provisions of Section 87(1) of the Elections Act, was required to investigate the alleged offence before making a report to the DPP. Secondly, the case made it clear that the court could address such questions, though not pleaded, so long as they arose in the course of the trial. The other distinguishing factor in that case is that the illegality was in fact pleaded. Evidence presented and tried as expressed by Election Court Gikonyo J in this passage of the judgment, and I quote, "In the instant case, however, the malpractices have been properly pleaded and laid bare before the court. What is remaining to establish is, 1, whether the malpractice was as a result of the scheme allegedly contrived by the first respondent to subvert the electoral process, and 2, whether the malpractice impeached the integrity of the electoral process, thus affecting the validity of the results." End of quote. The Supreme Court, we believe, has settled this question without doubt in Zakaria Okoth Obando, which bears some similarity to the instant appeal. In that case, the court delivered this position, reproduced in extenso because of its importance, and I quote, "The appellate court in its judgment relied on the DR's report and made observations on matters that had not been indicated as disputed in the trial court. A reading of the record shows that the DRs, after retally, found that the winning margin of the returned candidate had increased. Such is a factor which the Court of Appeal ought to have taken into account, rather than just highlighting the irregularities, oblivious to their lack of effect upon the declared results, which lack of effect the Deputy Registrar's report had illuminated. Besides, the trial judge is not to be faulted for upholding the appellant's right of fair trial by disallowing surprise new pleadings by the first respondent at the stage of final submissions. Part of that decision of Obando has been quoted in extenso. I will not read the entire quote, but you'll have the benefit of looking at it when we give you a copy of this judgment. We have highlighted the last sentence. The sentence that is highlighted is, however, where a trial court exercises its discretion and suo motu orders a scrutiny, recount or retally, revealing irregularities other than those that were pleaded, then there is a proper basis for any party to pose questions upon such new findings. And the court then will make findings on the effect of those irregularities on the declared results. End of quote. We have highlighted the last sentence because that is where the distinction lies. That it is only in situations where the court, in exercise of its discretion, orders suo motu a scrutiny, recount or retally, and irregularities other than those that were pleaded are revealed, the new irregularities may be relied on in the final determination of the petition if the parties are availed an opportunity to pose questions upon such new findings. But if a party petition an election court alleging non-compliance with any written law relating to that election, or that the nature of non-compliance was such that the result of the election was affected, then the party is bound by those averments because the burden remains upon that party to bring evidence in proof. Thereafter, the petition must be decided on the issues on the record. And if it is desired to raise other issues, they may be placed on record only by amendment of the petition. It was not open to the learned judge to rummage through the handwritten notes and the first respondent submissions to find something to use to nullify the appellant's election when the order for scrutiny was unambiguous. The DR was directed in the relevant part of the order to prepare and place on record a detailed report of his findings. That report, the judge further directed, was to form part of the proceedings of the court. In his own ruling of 13th of February 2018, the learned judge was more than clear when he stated, and I quote, "The parties are to submit on the basis of the report of the DR and shall limit their submissions to points of law and the facts set out in that report. The opportunity to file written submissions should only be limited to the setting out of the legal arguments of the parties and not to evidential material. I shall accordingly order that the petitioner's written submissions be limited to arguments and legal authorities. Any other document of evidential nature be excluded. Counsel to submit purely on the basis of the report of the DR, as that is what is part of the proceedings." End of quote. The Supreme Court in
Right, and that is the delivery of the ruling currently ongoing at the Court of Appeal regarding that appellate case by Charles Njagua, and the court has upheld his election as Starehe Member of Parliament. Let's take a look at international news now, and the world is still